have a very interesting show. We have two, count them, two guests. Our first guest in the first portion of the show is going to be Rex Hime with the California Business Properties Association, and he will be talking about the California Split Roll Tax Initiative. And if you've ever heard of Prop 13, it relates to that. And then we also have with us Ira Meislik. Did I pronounce that correctly, Ira?
Perfect. Yeah.
Whoa, how do you like that after all these years? Ira and I have both been podcasting, blogging, and whatever. He's been writing for many years, and we actually go back about 8 or 9 years, 10 years, something like that. He's a very knowledgeable and experienced attorney, often writing on commercial real estate leasing issues. So, before we go on further, let me just do a station identification, and we'll be right back. Okay, we're back, and that didn't work. It almost worked well. I'm missing Rex for some reason, and I don't know why I'm missing Rex. I actually had something there. So I'm going to bring in Rex Hime, and then I'm going to be working on getting the rest of us in on one of these panels. So Rex, if you would, please introduce yourself.
This is Rex Hime with California Business Properties Association, an organization that represents all of the commercial real estate interests in California and all of the national real estate organizations, ICSE, NAREIT, BOMA, ICSE, NAIOP, and IRA, etc.
Well, Rex, can you hear me?
Yes.
Great. So why don't we start out with you? Why don't you start out with a brief history of CRE Radio and TV? Not that you need to do that. Why don't you start out with an explanation of what Prop 13 is and what it does with regard to real property taxes? All right? Why don't you go ahead? Give a little history on that, too. And at least for the moment, let's not try to sell on your position.
I would never do that.
No.
So let's start with the fact that California, in the California Constitution, all properties and have always been the same way. In 1978, the voters of California adopted what is now known as Proposition 13, and what it did was it defined how that property tax would be constructed. And what it is that when you buy a piece of property, 1% of that becomes the tax, and that becomes what is known as your base year, and unless you do tenant improvements or make significant changes, that remains what you pay taxes, with the minor modification of up to 2% increase on your tax each year. So if you were taxed on $100,000 and you were paying $1,000 in tax, the next year could be $1,000.20. But you knew exactly what your tax was going to be, and you had control over whether or not you were going to increase the value of your property or not. It wasn't just done by an assessor driving by, which is how it had been done previous to the election in 1978. That's
great.
A dirty background.
Okay, so Rex, I don't know. Yeah, just kind of move the camera a little bit away from your face. That's much better. You were getting a little scary. We just about had your eyes and your nose, and that was about it. So why don't you tell us a little bit about what this new split roll tax initiative is?
Well, there is a measure that is already on the November 2020 ballot. That was begun circulation by signatures in the 2018 ballot. It qualified for the 2020 ballot, and what it does is it requires that the assessors in California reassess all the commercial properties, of which there are probably in the neighborhood of 630,000 plus commercial properties in California, to a 2020 value, and then that becomes the new base year, and then all commercial properties will have to be reassessed within every 3 years thereafter. The residential properties will remain with the protections of Proposition 13, and the commercial properties lose their protections. However, there are a couple of flaws in the proposed the measure that's on the ballot that the proponents were unfortunately impacting their own allies. And so in an effort to fix that, and because it had been targeted for the 2018 ballot and suddenly it was going to be at the 2020 ballot, they are now in the process of attempting to gather another million signatures, which will cost them about $10 million, so that they can rename it the Local Government and Schools Communities Act of 2020 as opposed to of 2018, and have the assessments begin in 2022 instead of 2020. They also made a couple other modifications to ensure that the high wealth school districts receive their monies, which they were precluded from that previously, and the one that's on the ballot currently. And then they set up a very convoluted method whereby small businesses, if they make up 50% of a property, that property can be delayed in its assessment. They are in the process now of getting that, getting set for title and circulation, and they have until May 1 to get 1 million signatures.
Okay, so I want to reiterate something here. For those who are not familiar with the way California does its real property tax, and I'm going to reiterate this, you basically have your tax basis established on the purchase price when you purchase the property. Right, the tax rate will be the initial tax rate is 1% of that value, correct?
Yep.
Okay. After that, every year, the tax can be increased 2%, correct?
Correct.
All right, and I think most people in California really like this tax as compared to other states where every year you could be reassessed. And so there is, and I know you're going to be using this term certainty, there's some relative certainty. That is, at least for landlords, not necessarily for tenants, because if your landlord sells your property and you're doing this tax pass-through, which is what Ira, Peter, and I will pipe in on, your taxes, the tax that you pay as a tenant could go up, the bottom line. But at least there is some certainty. Now, the people who are proposing this rule, who are they?
Both measures are the California Association and the Service Employees International Union. Both of them are public employee unions, and the estimated revenue from this change in Prop 13 would be about $11 billion plus a year.
So my assumption is that the teachers union is looking for this as a way to raise money for teachers, which, by the way, I think, and I had mentioned this to you before, I think teachers are grossly underpaid. But I'm not sure that this is the way to go about doing it, number one. And the other union, could you repeat what that union was, and who do they actually represent?
Service Employees International Union, SEIU. They are the purple shirts. They range from janitorial services to all sorts of other both private and public sector unionization.
Now, they're purple shirts as compared to brown shirts? That's a...
I'm sorry?
I would move on, Howard.
Yeah, that probably wasn't a good joke. All right, sorry about that. Ignore that. Only people older than you, Rex, would actually know what a brown shirt is.
Let's assume you're talking about UPS drivers, and we'll move on.
Oh yes, yes, yes. Okay, I'll assume that. There you go. All right. So now we get to the real. While this does affect real estate, we have a number of commercial real estate leasing experts in the room here. Peter Morris, who's my co-host, and I didn't introduce him, and I have Ira Meislik, and I will hold off introducing Ira when we get to his segment of the show. But here's the issue, so that anybody who's not familiar with commercial real estate, or probably anybody who is, at least from my experience, nearly every commercial lease, other than a gross lease, and I think most of the leases that I deal with now, have a tax pass-through, which means that whatever the taxes are, the tenant pays. So any increase in taxes, real estate taxes, the tenant is going to be paying, not the landlord. And then, of course, the question is, if the tenant is going to be paying this increased tax, who do you think that's going to be passed on to? Ira, give me your thoughts on that.
Well, it's no different than any other expense. And so if the market permits products or services to be repriced, then it will be passed on to the buyer. In most cases, however, the market doesn't permit that because it's a competitive market. So that if you're talking about products on their prices are generally not set by the seller's cost. They're set by whatever people are willing to pay. And in today's world, unlike 1978, when Jarvis got behind this and it got Prop 13 passed, there's a lot of knowledge about pricing and there's an online competition. So there is some chance it will be passed along to consumers. My economic head tells me that much of it will be absorbed as an expense, and to the extent that sellers need to review their other expenses, it may reduce service. It may have nothing to do with anything. Eventually it will sort out because everybody will be on the same page. I'm not sure if that's the answer you're hoping to hear, but it's my unexpert view of how the market works.
Well, actually, I love it when people don't agree with me, because the truth be told is I don't have a crystal ball, and I've been wrong an awful lot of times. I've been around long enough to make a zillion mistakes and be wrong. So I love it when people disagree with me. Peter, what's your take on this? And then we'll get back to Rex. And I can't hear you. Okay, hold on a second. Can anybody else hear Peter?
You know what?
Now I can hear you.
I put my microphone on mute to get rid of any background noise, and I forgot to take it off mute. Anyway, let me give you my 2 cents worth. Yeah, well, that'll be 4 cents worth. So a couple of things to spring to mind. Number one, these people that are proposing this don't consider that potentially they are the end payers of this. So my concern would be, as properties move from 1978, 1985, 1997 tax assessment up to 2020, there'll be a huge hit. And Ira correctly pointed out that it won't be able to be passed along generally to the consumer. We're seeing since 1978 a huge shrinkage in gross margin across the board in all industries, including manufacturing, not just retail. I know that Rex represents ICSC. And so I have a feeling that what's going to happen is the same thing that's currently happening in my neighborhood, Vancouver, British Columbia, where the taxes are assessed on an annual basis, and the assessment roll has spiraled out of control. And because of the way the taxation is done here, we're finding a lot of small businesses are simply going out of business. We're finding that landlords can no longer be competitive, where their operating costs equal the base rent, which should never happen. And so we're seeing some major hits there. Ira's quite correct. At some point in time, it will even itself out. But how many businesses will have to fail before that occurs?
Yeah, that much I agree. And the question that I pose is, okay, the taxes that are going to be paid by the tenant it may just put them out of business. I mean, what are they going to do? All of a sudden their costs are. And what I've seen is in many instances where the tenants negotiate a lease that doesn't account for instance, let's say your landlord has owned the property for 25 years. So the taxes that you pay as a tenant is not all that bad, or perhaps you think. Then all of a sudden they sell the property and your tax bill will increase tenfold. I mean, it just becomes crazy and people go out of business. And all I ever heard under those circumstances were complaints from tenants. And the landlords couldn't shoulder that cost.
Yeah. Howard,
the only reason.
Go ahead, Ira.
I want to make three general observations. One unconnected to the technicality of this. My recollection from 1978 was that the reason that Prop 13 was successful and promulgated, it was an attempt to reduce what California spent, less so than what people paid. The thought was that if you starved California of revenues, then California would not go overboard with providing enhanced college opportunities for whatever. I'm not going to make a comment on that. And that this movement, the sponsors of this, are really on the other side of that seesaw, who are looking and saying, okay, you've hurt us by reducing revenue and you've reduced the source of funds from which we would get paid and for which improvements would be made to education, government functions. Rex probably, I'm sure Rex has a much better handle on that, but I think this is just the other side of the mirror, the other side of the seesaw. As far as paying taxes, I think that tenants look at a total occupancy cost and a landlord can rent space based on a total occupancy cost, because to the extent that there's a merchant in Oregon who is leasing space, that merchant's paying its full share of taxes as they go up year after year. Whereas in California, the tenant got the benefit of a tax freeze or a tax limitation. And yet I don't think the prices are any different in California versus Oregon. I think what happens is that the rent is higher in California for the exact same spot across the border in Oregon. And what's going to happen is that it's landlords who are going to have to face how to get an occupancy cost that tenants will pay to be in their space. And that means I think that landlords will see lower rents. The last point is that you'll probably hear this when we get to my segment. There's a key element in any of these leases and other arrangements, and that's bargaining power. And in my experience, representing anchor tenants in California, the leases that I've represented do not permit an increase in taxes upon the sale of a property. And we can talk about the economic underpinning for that argument. Smaller tenants, the kind that Peter is referring to, and there are many, many more of them in number, they don't have the bargaining power to have negotiated, or maybe even the wisdom to have asked for such provisions.
That's correct.
And there's going to be a disjuncture and a change. And so I want to ask a question of Rex as to whether there's any transition rule, as there are in other places where taxes change on reassessment. New York City has a transition rule. Chicago has a transition rule. Here there's going to be supposed to be a rapid jump. And perhaps if this is going to pass, then the amendment, there ought to be by amendment to get some form of transition. Rex, I don't know, I'm new to California, and I haven't figured out where the bathroom is, let alone how this works.
Well, they believe the transition period is by giving the assessors up to the year 2022 to have it implemented. So as far as that, there isn't like this gradual, let's all sort of blend in here. And I'd like to make a few different points, if I may. First off, we've been talking about landlords and tenants, but a lot of small businesses in California are the landlord and the tenant. The guy who owns that corner taqueria, the fellow who owns the dentist who owns the place where his dental is, and the insurance office next to him and whatnot, who has bought that little building 15, 20 years ago. And those kind of people are going to be wiped out. When you talk about losing small businesses, last year California lost 18,000 small businesses. The Ledge Analyst Office estimated that there'd be 130,000 plus jobs lost with this proposal. And that the people who are going to be hit most, that rightly pointed out, are the small businesses, because they have the least leverage. And one of the proponents said, oh, well, by having this thing phase in over a couple of years, tenants will be able to move if they're worried about their landlord increasing rents. Well, that shows, I think, a pretty fair amount of lack of understanding of what location and customer base is and all that is. And it deals with the fact that I'm not going to be able to move my pizza shop from the corner of 12th and L Street to the corner of 27th and L Street, assuming I can get out of my lease, and think all my customers are going to move with me and that everything's going to be just copacetic and no change. These guys are going to be wiped out. And as it relates to putting out the market, the Best Buys, the Walmarts, and Targets, they have a large array of products. They'll be able to spread out any kind of increases in those places where they have leased property. They also own a lot of their property. In both instances, again, they'll be able to spread those out. If you make pizzas, or you shine shoes, or you are dry cleaners, your products, you don't have a lot of products to spread that price increase out. So you're going to be hit the hardest. And on top of this, the proponents have not talked about the impact upon pension funds. In a lot of commercial properties, pension funds have invested in a lot of commercial properties in California. And PERS, the Public Employees Retirement System in California, has estimated that there will probably be potentially a 5% loss of value when this gets kicked in. Well, when you have a $500 billion portfolio, 5% is a lot of money. And if you have a smaller portfolio, 5% is a lot of money. And that means not only does the value of the property go down, but in turn, so does the value of your pension fund. So these folks are creating a lot of problems that they're not addressing. And they really don't understand the economy. But you know what, Howard and Ira and Peter, they don't want to understand the economy. They want to do what they believe is the right thing to do.
So, Rex, what do you
Rex,
really think? Go ahead, Peter.
I was going to say, Rex, what do you really think? But, Rex, I got a question for you. I mean, you make a good point.
Can you speak up a little bit, please?
Certainly. Rex, you make a good point. I'm just moving my microphone up here. With respect to the pizza parlor. But the issue in my mind, using your analogy, is that the pizza parlor is just going to trade location A for location B, but it's still going to be subject to the tax unless they leave the state, or unless they move
just go out of
one of these
business.
buildings that you say, or go out of business, or unless they find a property where 50% or whatever the number is of tenants are small businesses, and then they're excluded. But the other question that I have for you, because you're more knowledgeable than I am, because I sit in Canada, is this. What do you think the impact is going to be on mixed-use developments where you are going to have that split between residential and commercial in the same building, and they may not have the same split when you're looking at, stratas, condominiums, or even rental properties?
That's a really good question, and one that this measure leaves in the eyes of the beholder. So the assessor, who will be making those types of decisions as to how and what the process will be. So it could be done differently between the assessor in LA and the assessor in Sacramento. And by the way, the assessors have expressed a great deal of concern over this measure, in the sense that it is going to create the need for, probably in LA alone, another 700 to 900 additional assessors, and then of course support staff for that. And then they're very concerned about the fact that there will be these challenges to the new assessments. Matter of fact, the Santa Clara assessor said he would expect his to grow from 3,000 a year to as many as 25 or 30,000 assessment appeals. He said, which they'd be incapable of trying to deal with. So that's another whole unintended consequence of what this measure is doing.
It's built-in work for people like Ira and myself. I've got one
absolutely.
Yeah, I've got one more question, if I might, before we move on, and let me get me into the screen here. Okay, so here's my question. I read the proposition, the proposal, and there was a provision that I didn't fully understand. Now, for those who are not familiar with California propositions, not understanding what they say or the ramifications is normal, all right, and not just for me. I hate the proposition process in California because who knows what's going to happen. With that being said, there is a provision in it that references an exemption with regard to personal property, and I didn't understand where personal property comes in. Maybe you can enlighten me on that a bit.
Well, that deals with the fact that in California, if it can move or if it can't move, if it's alive or if it's dead, government wants to figure out a way to tax it. So this tax that they're referring to are the taxes that you would pay, for instance, on all of your equipment and those types of things that you have in your office that are contributing to your ability to do business.
Well, that's a different tax. So that's not an ad valorem property tax. I still don't understand it. Thank you for explaining it, but I still don't get it. Do you have anything else to... Well, Peter, hold on a second. We lost you.
I was just going to say, Howard, I think because there's an exemption from it, is that the assessor wouldn't be able to add into the tax the value of the chattels. I think that's the intent of that, just from what you were saying, but I may be wrong.
Well, we'll have to look further into that. Rex, is there anything else you'd like to add at this time before we move on with Ira?
No, I really appreciate this opportunity. I appreciate being able to talk on this issue, and I look forward to future opportunities as this measure moves along.
Great. Well, thank you very much, Rex. Please drive carefully, and I will be talking to you in about another week. All right?
Perfect. Thanks, Ira. Nice meeting you, and nice meeting you, Peter. Bye-bye.
Thank you, Rex.
My pleasure's mine. It's obvious that, everyone's got taxation problems, and I thought ours in Vancouver, BC were tough. But this one, I know Ira may not 100% agree with me, but I have a feeling that there's going to be, some short-term pain. I think it was Rex or you mentioned that it's a jump. I think it's a long jump, and I have some concerns.
Yeah, so do I.
I was referring, for instance, in New York City, when property is reassessed, the resultant tax increase is incremented over 5 years. And so whenever there is this increase, and it could be every year or every two, and so it becomes a cumulative, there's a formula for doing it, the entire impact of the increase is not felt in the first year. Here, because this law is over 40 years old and properties which have not changed hands for quite a period of time, perhaps even 40 years, the change in assessment will be dramatic. Presumably, a tax rate will come down and reduce the tax rate for residential owners, because the way you determine the taxes, you look at how much money you need, you divide it by the total valuation of all property in your base, and then you come out with how many dollars per 100 tax that you need. And so if you're taking one component that is a commercial component and increasing that, right, in terms of assessment, you're increasing the total assessment, but the amount of money that's to be spent in the budget for that year or the next year hasn't necessarily increased. And so the tax rate goes down. It's a small benefit, or a benefit to the people who still benefit from the freeze, residential properties, and it is a small pullback for commercial owners from what it would be if you just multiplied your tax by the amount of increase in your assessment. But at the end of the day, the jump is an incredible jump, and it hasn't been planned for. What I was emphasizing is that people were paying total occupancy costs. When somebody rents a piece of property, if they think about it, they say, well, what's my total cost going to be to get the use of this property? And you add the rent, and you add the pass-through items such as taxes, and you add the operating costs or common area maintenance costs, whatever you like to call them, and your own insurance costs and so forth. And you say it's going to cost me $8 a square foot, $80 a square foot, whatever the number is going to be. And here all of a sudden you're paying 80 and it's going to 90. That's a very big jump. But for the next person coming in, if they only want to pay 80, the landlord's got to take the $10, or at least got to share some part of that $10. And once that reaches that point, you're in the same situation as you are in every other state in this country, where because I'm not aware of any other state that has a Proposition 13 freeze. And I don't, as I said, I don't think the rents are lower in California. I think they're the same on an equalized basis with any other place. It's just that the landlords were getting a larger piece of the rent. It's hard to say in any individual case, but overall, that's what the economics would seem to result in.
Well, why don't we move on? Thank you, Ira. So, let me just introduce you, Ira, that this portion of the show in which we're going to be talking about operating clauses was inspired by an article that Ira wrote describing or talking about or evaluating a state of Washington case that he had mentioned that he represents a lot of anchor tenants and related to a supermarket. So if you're watching this, I will provide links to Ira's article. Ira, why don't you, in 30 seconds, tell us a little bit about you? About yourself, I'm sorry.
Good-looking guy.
That's a matter of opinion.
You can see for yourself. I'm sure, Howard, you'll agree. I've been at this since, as an attorney since 1986, as a business person well before that, because I was vice president of operations for a medium-sized public company before moving into the practice of law. And so I've got a great deal of experience on the law and business side of commercial property, representing landlords and tenants, large and small. Been thinking, I think that my single most unique criteria is that I think about these things every day and haven't stopped learning. And,
Ira, get a life.
Yeah, well, no, this is I have a wife. Of 55 years, I should point out. But and over time, my thinking has both developed and changed. And that's what excites me, is that I don't think that I'm stuck in what I thought 30 years ago or 30 minutes ago. And you're going to be giving a link to one of my least intelligible blog postings. But I'll take, when you have 500 of them, all right, some of them are better than others.
Yeah, that's interesting. Your articles, blog posts, tend to be a little bit on the lengthy side, but
intentionally.
Yeah, and this one I'm reading, and I'm going. First, I'm reading the provision, and I'm going, oh my gosh,
Yeah.
But with that being said, it really did catch my attention. So why don't we move on? Ira, why don't you lead on this and tell us what an operating clause is?
Okay, well, an operating clause, an operating covenant, is an agreement by a tenant that it will operate either or both during certain hours and certain days, and either for 1 day or 10 days or 2 years or for the rest of eternity, however long that might be, whichever comes first. Essentially, the tenant is saying, we will be open and operating for business, and you, the landlord, and our companion tenants, perhaps, will have the benefit or can rely on our being there and drawing business to the location, which is why a bunch of tenants get together, in herds, because there's a symbiotic relationship. I bring customers to you, you bring customers to me. And so landlords like to get those provisions, even if they haven't thought that through, or even if they haven't distinguished between whether it's really important for a particular piece of property or not. But basically, it's a promise to be open and operating for business. There are details that go with that. I want to point out with respect to the article, the piece points out that a court of appeals eventually said these very lengthy provisions are really very lengthy, but they don't really accomplish what you, the landlord, are telling us they were supposed to accomplish. That case fell apart on the drafting, on the structure of the language and the provisions.
Yeah, let me interrupt you a second. And instead of giving us the whole article right now, let's include Peter for the moment. Okay. Let's bring Peter into the conversation. I want to stick with, what an operating clause is, what the benefits are, and, basically from the tenant's perspective, why you are going to agree to an operating clause.
Well, I'm going to agree to an operating clause if I'm a tenant because I know that it's beneficial for me to be open, and more importantly, it's beneficial to me that everybody else is open, as Ira pointed out, because there's going to be the anchor store, it's going to draw traffic. I don't want to be in a position where I'm open and everybody else around me is closed, because that is going to put me in no man's land. I'm going to be a deserted island in a vast sea. So operating clauses are important from that standpoint. Flipping hats over to the landlord side, if there is percentage rent to be had, then that's important as well, because you know that you're going to be maximizing a percentage rent opportunity within the property. The other thing is that we've all walked down the old style downtowns where you would have a restaurant that's open late at night and everything around it is closed. And so there's some security concerns, some other things that arise if you have hit and miss. And so the operating clause is intended to provide uniformity across the shopping center.
Yeah, now, this only deals with retail property, primarily shopping centers or malls. Why don't we talk... Before we get to that, I'd like to mention, just as an example of when businesses are closed, because during the recession, I did a lot of work for a special servicer who would acquire these properties by foreclosure, shopping centers, etc. And this is going back to the 90s when I represented the RTC during the savings and loan collapse, etc. And one of the things that we learned is not to empty out a shopping center. If there are tenants in there, don't kick them out, even if you're not getting rent, because it's so much more difficult to lease space in an empty shopping center because there's not the mix. The tenants want to be among other tenants. They all rely upon each other. Tenant mix is extremely important. Ira, let's go to you for a moment, and let's talk about it. We're leading up to the case. I'm kind of setting it up. Let's talk a little bit about exceptions. Are there exceptions that are typically allowed in operating clauses?
Okay, well, some of the exceptions are general and some are specific to a tenant. Peter, I will tell you, I agree with you that tenants should like operating clauses, but that's a little too altruistic, because I think a more accurate and narrower statement is that tenants would like every other tenant to have an operating obligation, but not themselves. And,
True, very true.
No, and that's where the negotiation comes in. So, Howard, in general, some of these are just not controversial. If I'm obligated to operate 7 days a week from 10 a.m. until 9 p.m., for instance, and if I don't, then you'll come punch me in the nose, because we need to talk about remedies. Otherwise, these are just words.
Well, the remedies the remedies are really important as it related to this case.
Well, this case or any other, because there is a general law, and this case started out as an outlier. But as far as carve-outs go, people don't want to be obligated. It's generally acceptable if the property is unusable because of damage, perhaps severe weather. I mean, if you're in New Orleans, you don't want to be obligated to be punished for not operating during Katrina. Labor inventory shortages are a little more controversial. Taking days off for inventory, special holidays. If somebody has religious obligations, perhaps they're not going to want to be obligated to be open. That's especially important for MAPAs. Maybe staff meetings, as people in the Me Too generation close down for a day so they get everybody together. Unavoidable delays, small tenants' vacations. These are all work-outable and generally not controversial. But where you do get some controversy, and in fact, one area that people don't think about is, what about in the winding down period? What about in the last 2 months of my lease term? Do I need to operate at 110% until just before midnight on the end of my lease, or do I get a break in the transition period at the end? How about, is it for the entire store? Suppose I need to skinny down. Sometimes by skinning down, that helps business because you get more pizzazz in a smaller space. The merchandise is stacked up higher, think of like water. So do I have to operate in the entire space? Those are subject to negotiation. Once you get past the issue of whether there's going to be one at all, then on the entire other side, the question is duration. In the olden days,
before you get to that, let me interrupt you a second, because you mentioned two things that I think that we should address. One of which was part of the provision in this Washington case. First of all, as you talked about the end of the lease, as a practical matter, I don't see that as an issue, honestly. If there are 2 or 3 months left in the lease and the tenant is starting to wind down, as a practical matter, the landlord really doesn't have any other options other than get a new tenant in.
Then you haven't seen the case for damages.
Oh, okay.
Yeah, or how about if the lease says you are going to have a penalty of X number of dollars for every day you're not open?
That's true.
You missed one other one. Ira, and that would be for renovation and rehabilitation.
Oh, yeah, remodel.
So if you're doing a refresh. And the other one, that you have to be careful of when negotiating is, must it be fully open and stocked and performing? What if you're in seasonal transition? Are you fully operated and open for business? You got to be careful of those ones, and a lot of people overlook that, as Ira pointed out.
Ira, stay on the camera.
Yeah.
You're off to the side of the camera a bit. Move to your right. Move to your right. There you go. Move to your right. Yeah, there you are. No, we're losing you. Yeah, the fully stocked inventory issue that was in that provision in the lease. First of all, well, there was so much about those provisions that were written poorly, but I was looking at that saying, well, it needs to be fully stocked in accordance with, I think, something like business practices or something. And I'm going, okay, how do you do that? I was just in, I'm trying to think of the store. Oh, it was Best Buy. And it was like, or Fry's in particular. I walked in there, half the inventory wasn't there.
Well, there's case law over that. And in fact, that's when we talk about remedies, that's one of the recurring points that courts raise about what does that really mean and who's supposed to have the judgment as to what's appropriate merchandising. So when we get to remedies, maybe I'll be able to elucidate somewhat.
Why don't you give us, if you can, a 3 or 4 minute summary of the case and the most salient features of it?
Okay,
This is a tough job for Ira.
No, it is a tough job. It is a tough job for me, but now I get the opportunity to say this case came up in late 2017, and it was just a couple months after another case, which is also important and it should be understood together, and that's when Starbucks intended to close down its Tivana stores. And Simon Properties sued Starbucks and got an order in Indiana that Starbucks needed to keep open its 77 stores in Simon Malls. That was subsequently settled. Then this case came up in Washington State in October, and the court ordered that the store reopen within 14 days. And the reason those two, really sent shockwaves through the industry is because there had never been a case where a non-anchor store was required to reopen. So research was done, and the papers filed in the Starbucks Simon case actually confirmed that this had never happened. And so there was some shaking in the legal community, probably in the business community as well. Fundamentally, the question is that after you have made a promise, whatever that promise is, either expressed in the lease or, Howard, if we have time, implied by other provisions of the lease, even though the lease doesn't say you must be open. But when it's determined that the tenant is obligated to have stayed open, the question is when they close, what can the landlord do? And so in this Whole Foods case and in the Simon case, and in some cases that Simon unsuccessfully tried before it sued Starbucks, the landlord wants the store to reopen, asking a court to give specific performance. Store, you shall reopen. And the measure is generally the balance of the economics. Who's going to be hurt more if the store is open, and whether a landlord can be compensated by money. I mean, in a car accident, if somebody's injured, I mean, they'd like to be restored to the way they were beforehand, but all a court can do is give money. You can't get a specific order, your bone shall heal, or your arm shall be replaced. And so the issue, after all is said and done, is so what if somebody closes? What can you do? There's mixed case law about large stores, anchor stores. Okay? And it depends on the facts. They're all fact specific, but there are plenty of cases which say anchor stores need to reopen, assuming the lease gave the landlord the power to ask for that. And there's a ton of law saying that small stores don't need to reopen. That leaves the landlord with damages. In this Washington case, the lower court ordered Whole Foods to reopen, and they said, hey, look, Whole Foods, you're not losing a lot of money, and this landlord will lose a lot of money. Preliminarily, give us time to decide what the ultimate remedy is going to be. But in the meantime, while we're figuring that out, you, Amazon, are not going to be really very hurt, and this landlord's going to be very hurt. Reopen. That's the same thing that the judge in Indiana said to Simon and said, look, I know there's all these little Starbucks Teavana stores are very small, but you've got 77 of them. Starbucks, you're a humongous company. You can bear the extra expense, and we don't even believe your expert testimony is how much you're going to lose. And Simon, the cumulative effect of 77 stores is going to be a big impact on them. So Starbucks, you need to reopen. We just can't find another way to make Simon whole. I believe that the Indiana case would have been reversed on appeal. We'll never know because they settled, and that's the way a lot of the disputes are settled. So the issue is not whether you can impose a requirement to continue to operate or what the limits of that are, but what can the landlord do? And the choice is between saying, here's how much money would make us whole as if you were still operating, and or we can't figure it out, so give us the benefit of the bargain, reopen. I'm going to leave out what rights the other tenants may have who are also similarly affected, but that's probably for another.
That's for another show. I have experience with a Starbucks that was going to close. They had a Starbucks in our center, and there was a Starbucks across the street. They had indicated that they were going to go dark. I call them go dark provisions. And they said, well, we'll continue to pay rent. And I, of course, representing the landlord, I went back and said, no. You know, this Starbucks is really important to this center. It's very, very important. So while Starbucks may not be an anchor, it's a very valuable tenant, which is why they have such strong negotiating strength. So let me add what we ended up doing. Now, they had this lease. It was a Dietrich's lease, which was another coffee chain that they took over. So they were sure that they had negotiated in this lease that they had the right to go dark. Well, if you read the lease, the people at Dietrich's weren't so smart, and they didn't have it. And as you had indicated, we settled, and they paid us a whole bunch of money because they figured it was cheaper for them to do that. And to what you were discussing, I wanted them open, but they paid us so much money, it was worth taking the money. Peter, do you have any similar stories?
I have a different one. I have one where it was an anchor. It closed. It had a continuous operating clause in it, in as much as it had to have a certain amount of stock. It did. The shopping center, the grocery store was squired away to a different shopping center down the road. It was the anchor for the shopping center when they closed. That created a huge amount of problems. The landlord, who was my employer at the time, desperately wanted to get the place back. They had a replacement tenant in place, and the departing supermarket did not want them there because it was a direct competitor, and as long as they paid the rent, they felt that they had locked out that competitor. Ultimately, they wouldn't settle, they wouldn't go to court, they wouldn't do anything, so the only thing that the landlord could do is, believe it or not, they bulldozed the building. They bulldozed the anchor tenant space on the day when the tenant's representative had to fly into town to verify that it was indeed stocked and it was indeed there. And he got on his phone and he said, the store is gone. And so what the landlord effectively did was terminated the lease. The grocery store then sued them. And that's exactly what the landlord wanted. It brought him to the table. Yeah. So the landlord had money set aside in order to pay this out. This was a way to do that one.
Yeah.
One of the questions I would have for you, Howard, is in that Starbucks deal, did the other small tenants that relied on all that traffic flow from Starbucks receive any of the money that the landlord got?
Absolutely not. As a matter of fact, but there was part of the problem. There were already substantial vacancies in the center. And another vacancy like that was going to kill the center. But there were smaller tenants. There was a Party City in there. So that's not what I would consider to be a smaller tenant. But I don't think that anybody knew enough. I'd love to talk about that issue, but I want to move on to a couple of other issues, which are the remedies in this particular case, and I think that Ira should talk about the remedies, which included the remedy of recapture. And if you would, Ira, start with distinguishing between abandonment and vacation of the premises, which will lead up to, that recapture right and why it became an issue.
Okay, well, in a normal vernacular, walking down the street, leaving a place vacant and abandoning it seem to have the same meaning. But as a matter of law, they actually are different. Vacant is what you would expect to be. It's a vacuum. You walk in, there's nothing in there. But abandonment means that one leaves with the intention of never returning. And that definition comes up in a lot of situations in law cases. It comes up in rezoning when you have a prior non-conforming use, how long you can preserve it. The test in most states, I can't say all, is have you abandoned the use, or you merely just, I'm always intending to reopen my auto dealership, or are you left within some indicia that you're not coming back? That's abandonment. And so when a lease talks about it being a default to abandon the space, as long as a tenant says, well, when business gets better, we're going to come back, or we have another business plan, we have another brand, another trade name to put on the store, we're looking for another, for an assignee or whatever, a subtenant. So we're not abandoning the place. I haven't abandoned. That's not my default. I just keep paying rent. Nothing in the lease says that it's a default if I vacate the premises. That's where the issue comes up, and I think that there are many of my colleagues who understand it, but there are far more of my colleagues, especially those who don't do this regularly, who don't understand the difference.
Let me add something here. Because I've handled hundreds or more evictions, the issue of abandonment versus vacation I'm very sensitive to, because it really goes to me to the issue of, has the tenant given up the legal right to possession? And legal right to possession is different from physical possession. And there are all kinds of remedies that may exist in the lease, etc. And at least in the state of California, if the landlord believes that the tenant has abandoned the premises, there is a procedure that the landlord can follow in order to protect itself if it wants to retake the legal right to possession. So they don't want it to be a forcible detainer where they could have committed a misdemeanor, etc.
Howard, I'm going to suggest that most of those cases, the tenant stopped paying rent. We look at the narrower class where the tenant has no longer operated the place, has taken everything out, but continues to pay rent. And that's where you need to look at the lease to see whether that's a default or not. That's the difference between vacating and abandonment. When you're not paying rent, you already have the reason to lose possession. If you needed to argue abandonment, one of the indicia is I'm not paying rent. If you intended to return and use the space, you'd be paying rent. But you don't even get to that because non-payment is such a simpler issue. From an old Amos and Andy episode, is the rent due and paid? And the answer is no, it isn't. Thank you very much. Get out of here. So abandonment versus vacation is really much more significant when the tenant continues to pay rent. So in the example that Peter gave, if the supermarket had stopped paying rent, they would have lost the right of possession to that space. So they continued to pay rent because they wanted to block that physical space. There's an old case in New Jersey where a tenant had an exclusive right at the center, okay, and was holding on to the space, precluding reusing that space for a competing supermarket, and also barring the landlord from putting up another supermarket in the same space. And I will say the court had its head on straight, and it said that the exclusive use right is meant to be a shield for the tenant, not a sword for the tenant to use against the landlord, and did not permit the tenant to do that. It was an old Huntington and Hartford supermarket chain. We'll leave it at the alphabet. We'll leave the alphabet out of it.
Okay, so we're running out of time, and I want to get to those two key remedies and what happened in the case. And the two key remedies was the right of recapture and the liquidated damages, because the liquidated damages really affect, from my perspective, the landlord's right to get specific performance.
Not necessarily, because they're not necessarily mutually exclusive. A landlord can reserve the right for specific performance even though it gets damages. Look, in the case we're talking about, the Washington State case with Whole Foods, just to get perspective, the store was 34,000 square feet. There were 3 anchor tenants there, Nordstrom's, Macy's, and JCPenney's, totaling 700,000 square feet in all. So just the Whole Foods versus the 3 anchors, they were only 5% of the entire space, which is the reason that historically a landlord, no matter what its lease says, is not going to get specific performance, because money damages will make the landlord whole, and the tenant is much more hurt by having to operate than the landlord would be missing this tenant and having to find another tenant. What happened in the Washington State case is, because of the poorly way in which it was written, the landlord, the landlord must have started out saying, "Hey, look, I want a remedy if you fail to operate for 2 consecutive days." And the tenant said, "Okay, that's fine, but you got to give us a break. It's like a late fee. That don't hit us with your remedy the first or second time in any calendar year. We're willing to suffer the remedy you ask for as long as it's the 3rd time in the year." And that often happens with late fees. We're going to waive the late fee. We'll give you notice. You'll pay it. All will be well. What happened here is the tenant closed. That was the first time. It never reopened, giving them a second time to close and then a 3rd time to close. So the way the clause was written, the landlord agreed to a negotiated thing which sounded good, because a lot of leases have that concept, but not for this reason. So, the remedies that the landlord had specifically negotiated for really failed because they were not in the lease. The landlord thought they were, is my guess. But I already discussed the difficulty in getting specific performance, because there's a balancing of interest, and courts prefer money. And by the way, so I'll give you a couple of things. Here's some kind of quotes from our Wegmans case, 1973 in New York. As to ordering specific performance, courts are reluctant to grant specific performance where such performance would require judicial supervision over a long period of time. Courts don't want to supervise. And another New York case said courts are not inclined to specifically enforce contracts which require the performance of varied and continuous acts for the exercise of special skill, test, or judgment. That has to do with how stocked are you. We're not in a position as a court, or even get a special master, to say, well, that's enough stock. No, you should have more dressers of this size. So, and there's similar cases throughout the country. It's replete with cases. So you can now come to damages, and here's what the problem is. The problem is it's hard to prove. It really is. How much is so the Starbucks closes, and there's another 500,000 square feet of space operating. What hurt the landlord? We know specifically they'll have to release. Or mind you, Starbucks is still paying rent. We don't have this default. The store is just vacant, and the landlord is saying, "What should I do?" So Peter mentioned the word. We all know the word recapture. The landlord wants to say that if you vacate the space, okay, we'll let you stay there and pay rent, but if the space is not being used for some period of time, give us the right to take the space back. We'll let you off the lease, or you'll pay us $3, but we'll let you off the lease. We'll look for another tenant. We want to put somebody in there. At least give us that break. We're thankful for your rent, but we want your rent and somebody present in the space. So recapture is an important thing for a landlord, and it is generally very easy to get because most tenants are happy to be able to stop paying rent.
But in
Proving
this
other money
case,
damages is nearly impossible. It's a fool's errand.
right, but in this case, the recapture clause had a problem, did it not?
Yeah, it was written by the same person or people who wrote the other clause. I mean, the way it essentially was written is that we could, this is, folks, do not write me. I'm going to give you the simple explanation. The landlord negotiated that if the tenant was evicted, it could then recapture the space. I mean, I know that makes no sense at all, okay? But essentially, that's what was written. And I don't think the tenant negotiated for that. I think the tenant was very happy to get off the lease without having to pay more rent and stuff like that if the landlord would take the space back. In fact, what the tenant would like to say is, hey, look, I'd like to just give you the space back and make this like my option to kick out. But again, it was a perfectly appropriate lease provision, one that would have been uncontroversial, and it was just botched, in my view. Now, maybe I misread it.
Ira,
I'm new to this.
Ira, I have to say a couple of things here, and I'm not wrapping up the show, but I got to say a couple of things here. I read that clause, and you know what I think happened, aside from the fact that they had someone who did not know how to write a clause. And I'm not a lawyer, so I can't pontificate on how to write a clause from a legal perspective. But it seems to me that what happened is the landlord had a very standard clause. And then over the course of the negotiation, they just kept adding words on both ends of the clause. And they just keep adding to it without looking at the context of what the heck they were doing. And then it flowed into the next provision, and they did the same thing. And they also didn't cross-check, which is one of the things that I always talk to people about the need to do. Make sure that you're cross-checking your document as you're going through the negotiation. I read this thing and I was scratching my head, and Ira made a great point. Yeah, we'll recapture it once we evict you.
All right, so let me give you a new Ira-ism. I never thought about it this way, Peter. The clauses that we find in leases should be understandable by people who are not lawyers. They may misunderstand them because they don't read everything in context, but the words should make sense. Okay? Even if they then interpret them differently, the words should make sense. And I'm not saying just anybody off the street, but people who read. You don't have to be in this business. And I think that that we get bollocksed up in trying to put in Latin words and put in words like said and whatever. And Peter, you're exactly right. Look, you're in the business, you look it, you read it, you should be able to understand it, you of all people. The more important lesson, because there's countless ways to write things poorly, the more important lesson is that the landlord is not going to be able in almost any case to prove damages satisfactory, and so the word liquidated damages come up. So for those people who are not clear on the concept, a liquidated damage is in contrast to what's called an unenforceable penalty. When you have at the outset, when you do an agreement, that you know there will be damages, and you know the damages will be certain, but they cannot be, you know that they will not be accurately calculated. The parties are permitted to make what's called a reasonable estimate as to what those damages will be, and then state that because that we know that we'll be damaged, we know there'll be damages, they will be capable of calculation, they won't be speculative, but they won't be able to be calculated precisely, and therefore we agree a reasonable estimate would be $500 a day. The reasonable estimate would be $7,200. Those provisions are generally, when structured as I described them, not just some number out of the air, not intended to be a penalty, when they bear some relationship to what could have been a reasonable damage, courts will enforce them. Sometimes in hindsight, courts look back and they say, well, how could you have been reasonable now that we see the facts? But generally, liquidated damage is an agreement on a per diem penalty. I use the word penalty, and that's a word you should not use in a document, but a per diem charge, administrative cost, that's a remedy.
Yeah, I got to stop you, Ira. That's liquidated damages is another whole discussion that we could spend an hour on. At a very minimum, we could spend an hour, and I've got many thoughts on that.
That's what these provisions need, Howard.
Yeah, no, they do, and we could probably
okay.
do that. Maybe we'll have you on another show where we talk about liquidated damages and my thoughts on the enforceability of those under certain circumstances. With that being said, gentlemen, I'd love to ask you your final thoughts, but I'm not going to do it because we're already 10 minutes over. And I'd like to thank you, Peter. I'd like to thank you, Ira. And with that being said, thank you, audience, and we will be back. Oh, before I even go, next Tuesday, I'm having Neil Bawa on a specific show about the 5... What was the term I used? The 5 things to watch out for in opportunity zones. And that's going to be a very interesting show. It's not on our regular Thursday, 4 o'clock show. This is going to be next Tuesday at 4 p.m. Pacific Standard Time. And if you want to learn more about opportunity zones, certainly give me a call and watch the show. Everyone, thank you very much. That's the end of the show.